Good afternoon, everyone, and good morning to those of you on the West Coast. This is Josh Willie, and on behalf of the Public Contracting Institute, I'd like to welcome you all to today's GovCon 101, covering structure and interpretation of a government contract. We are joined by our expert instructor, Fred Gelden. Before we jump in, just a few housekeeping announcements. For our GovCon 101 sessions, there are no passwords, but there will be a few polling questions at the end. Your participation is important, so please make sure you stay tuned in till the end to complete those polling questions if you are seeking credit. Questions are welcome at any time, but we will take questions at the very end. If you have any technical difficulties, please make sure to let me know. I want to make sure you have a great experience. And with that, I thank you all for joining. I will hand it over to Fred.
Thank you, and welcome everybody. And I do want to encourage questions. That's the best way to make sure that I'm filling the gaps and basically responding to what's important to you. So let's start. First, an introduction. Um, I am currently senior counsel at the Steptoe Law Firm. My area, of course, I'm part of the government contracts group there. But my area of specialty is actually compliance and organizational conflicts of interest. But we cover pretty much every kind of government contracts issue in our group. Uh, Maybe more important, I spent 21 years at Electronic Data Systems. I was managing the contracts and legal group for a good part of that time. And in doing that, we were the group that supported EDS's government business, federal and state and local. And so there were lots of issues that came up, and some of the things we're going to talk about today reflect that. I may even bring up a couple of examples if I think they're helpful. Um, so with that, let's talk about what we're going to be doing today. We'll spend the first part of the class of the webinar talking about really what a government contract looks like, what the structure is, where you find things, where they're placed, what the significance of that is. And then we'll spend a little more than half the time probably talking about really what that implies and the do's and don'ts in working with government contracts and interpreting them and following them, the traps that you can fall into if you're not careful, etc. So with that, um, let's start with some terminology. We have the solicitation itself is the starting point in a procurement, at least from the standpoint of the contractor. And we're dealing with mainly with Part 14 or Part 15. Of course, you also have Part 12 for commercial items and 13 for a simplified acquisition. But their terminology is a little different. I'll mention that in a moment. Basically, you're soliciting proposals from offerors if it's Part 15, or if it's Part 14, you're soliciting bids from bidders. And then when the bid or offer is submitted, that bid or proposal is submitted, that constitutes the offer. When it's selected, that constitutes the acceptance. We have acceptance of an offer, meeting of the minds, consideration flows, and we have a binding contract. Typically, you'll see provisions in solicitations, we call them provisions, which then get incorporated verbatim in the contract itself. So you'll see the same language, and it's a provision if we're still in the procurement phase, a clause if we're in the contract phase. And as we go through the structure of the contract, we can keep in mind that what we see in that structure really applies to both solicitations and proposals. Now, I mentioned I would, actually, before we get to the next slide, I mentioned that Part 12 and 13 are a little different. I don't have the slide that reflects it, but what I'm referring to is that in a Part 12 or Part 13 procurement, where commercial items or simplified acquisition, we don't use the term proposal or provision or RFP or IFB. We use the term request for quotation, RFQ. And a quotation from the contractor is basically a price list. It is not an offer. And so when the government issues an order in response to a quotation, it is not accepting an offer, making a binding contract. Rather, it is making an offer. I offer to buy from you at the price quoted in your RFQ, in your quotation. And the contractor will normally say yes. That's why they offered the quotation. But they don't have to. They actually have the right to say, well, times have changed. We don't accept your offer. It's only when the contractor accepts the offer that it becomes a binding contract. Contractors can do it formally and usually should. They can also not formally accept it, but start performing. And that constitutes acceptance. That also has the risk to the contractor of allowing the government to change its mind. Government issues an order, that's an offer. Contractor starts to prepare to respond to the offer, but never formally accepts it. Government says, we don't need it anymore, and rescinds the offer. It's no longer an offer, and the contractor has now spent money preparing to fill an order that is gone. That's why it's a good idea for the contractor to accept that order. All right, back to the RFP or the IFB. And typically there is a uniform contract format. And this is very useful because we find it in both Part 14 and Part 15. And we find it as appropriate both for the solicitation phase and for the contract. It's the same format. Now you see the numbers there. You see it's currently in the FAR, it's 15,204, which is the same as 14,201. Now, why do I have numbers in red? Because as you're probably aware, a year ago, by executive order, the FAR Council was directed to update, to revise the FAR, to streamline it, to basically try to make it shorter and simpler and more readable, take out anything that wasn't statutorily required, put those in buying guides, a whole bunch of changes. And that in itself is a massive project. Amazingly, they did come up with the revised, what they call the revolutionary FAR overhaul by the due date, which was September 30th, 6 months later. That's not yet formally in place, but they also directed the agencies to issue what we call class deviations, to use the new FAR rather than the old, the RFO rather than the legacy FAR. And many, not all, but most of the agencies have done that. Not necessarily uniformly. So if you're dealing with an agency and you want to know which version of the FAR they're dealing with, you actually have to look online and see, not just whether they've accepted a particular or done a class deviation for a particular part, but for each part. But for our purposes, it's the same uniform contract format. It's just the red reflects the numbers in the RFO. So depending on which version you're using, that would be just where you would find it. Now I'm going to stay with the uniform contract format. It's divided into 4 parts. The first part, you can see them listed there, and let's drill down a little bit. We don't usually think of it in terms of parts. If I say part 2 of the uniform contract format, you'll go, what's that? But if I say we're dealing with section C or section M, that's what people know too. So that's really what we're most concerned with from a learning standpoint. And now let's start and look through the specific sections. And in the first part 1, it's the schedule. You can see the sections listed. I'm going to walk through each one in detail, starting with the cover page, which is the solicitation contract form. It identifies a number of the important features, the important details of the procurement. Of course, it gives you the number of the procurement and the date of issuance so you can identify it. The contact information for the contracting officer and sometimes for other government representatives. The date that the proposal is due and where, time and place. A table of contents for the rest of the solicitation. And I'll show you an example of that in a moment. And then the offer expiration date. That will also be there. In addition, it may have information about whether or not this is a small business set aside, whether it has a priority listing, things that are details of the procurement. So here's an example of the table of contents for a particular RFP. The solicitation was page 1. You can see the supplies and services, section B, was 10 pages. The work statement was 61 pages, and you can follow along and see what's in there. All right, what about section B? Section B is basically the price list. It describes the various products or the various services by what, kind of in a summary fashion. And it provides the pricing structure. So every single item, every single contract line item number will have a price. There may be subcontract line items that are even specified. Sometimes if it's a multi-year contract, maybe 1 year with 4 options, there will be separate lines for each year. And it's basically what you're going to use if you're the contractor. You're going to use this to prepare your price proposal. You're going to have a number for each of these items, and then carried forward into the contract. That will be the price for each of the items. All right, section C is basically the work share. What the contract work is, what is being provided in the form of goods or services, products or services. Describes the agency's need. It's a statement of work. Sometimes it's a performance work statement. Now, the difference there is that if the contract is what we call a performance-based contract, the goal will be the specification, the solicitation won't say, here's exactly what you should do. Rather, it's going to say, here's the result we want. And it'll be defined by a performance work statement, which isn't always in the actual contract. It'll be the proposal that goes into the contract. That'll be a statement of objectives, basically says, this is what we want the result to be. We're not going to tell you how to do it. We're not ordering 50 widget 103s, and we're not saying we want you to have 50 hours of this kind of service. Rather, we're saying we would like the lawn to be maintained, and we would like the grass to be no higher than 2 inches. So you figure out how often you have to mow it. Or we want the facilities to be cleaned, and that means the bathrooms should be cleaned so that they sparkle. We won't tell you how often you have to do it, but your proposal will do that, and that will be the statement of objectives says this is our goal. The proposal will be this is how we plan to do it. That's tricky to do it that way. It's got to be clear as to what's required. It can't be ambiguous. And of course, as a general matter, you don't want the specifications to be unduly restrictive, which means limiting competition. If I'm the agency and I want to buy a new car, if I said it has to be a Chevrolet Malibu, that's unduly restrictive. After all, what do I need a new car for? I need it to drive, take people, maybe passenger, maybe luggage, maybe other equipment from point A to point B. But a Malibu is only one particular kind of car that does it, and there are, of course, hundreds of others. And so if I were to restrict it that way, I'd be excluding anybody who sells anything other than a Chevrolet, and probably incur a bid protest that would succeed. Okay, what about the next section, D? Well, packaging and marking. How do you want the stuff to be marked? How do you want it packaged? Now, at this point, let me point out, when we deal with the specific parts, if you're the contractor, working for the contractor, there are certain parts you're going to care about depending on what your job is. If your job is in the pricing area, you're going to look at part B. If your job is in operations and putting together your team, you're going to look at part C. You'll have somebody who is looking at packaging and marking. It's probably only one person, certainly a small number. And the virtue of having the uniform contract format is when you see that solicitation, you know where to go. You know exactly what to look at. You don't have to spend a lot of time looking at a 100-page solicitation when it's only 2 pages that are going to matter to the part of the job that you're doing. In this case, packaging and marketing. Inspection and acceptance. How is the government going to decide whether or not what you deliver is acceptable? What are the warranties that are associated? What liability is there for loss or damage? That will typically be in an incorporated FAR clause. Later on, we're going to talk about the FAR clauses that we find in a typical solicitation and contract. But here's worth noting that sometimes these earlier sections also will contain descriptions that are defined by FAR clauses. Okay, time, place, and manner of delivery. Again, depending on what your role is, this may or may not be the part of the procurement you look at. Of course, if you're on the government team, similarly, there are parts that you're looking at, parts that you're preparing, and parts that govern what your job is. Okay, contract administration data. That's telling you who's going to be responsible for doing what. Who is the contracting officer? Who is the contracting officer's representative? If there are other people involved, which problems, which issues do you bring to the attention of the contracting officer's rep? Which issues do you not? It's basically giving guidance about the personnel who are going to be very important in administering the contract. H, contract requirements that are special clauses that just apply to that acquisition. It's kind of I don't want to say catch-all, but maybe that's the best term. Things that don't quite fit somewhere else, but they're part of the solicitation. You'll find them in section H. It may be blank, it may be quite voluminous. Let's go back for a moment, look at the table of contents. In this case, special contract requirements, there were 22 pages, so clearly there was a lot in that section H. Okay, then we get to part 2, and part 2 is just the contract clauses. Those are the famous FAR clauses that we know and love, or maybe don't love. And in part 3, we're going to get into the documents and exhibits and attachments that go along with the procurement as well. So let's stay with section I, contract clauses. It will include the FAR clauses. It may include some agency supplement clauses as well. So if it's a Defense Department procurement, it will have some FAR clauses. It'll probably have a number of DFARS clauses, Defense FAR supplement, similarly with other agencies. Now, here's the trick, and we're going to talk about a pitfall that sometimes people fall into. A lot of times what you see are lists of clauses. They're not spelled out verbatim. Instead, what you'll see is a particular clause, let's say 52.232-5, I'm just picking that one out of the air, with the name of the clause and the date of the clause. It's incorporated by reference, which means that it's part of the contract, part of the solicitation initially, and then part of the contract that is just as binding as any other part, but we're not spelling it out. You have to look somewhere else to see what it says. And it's a convenience. It's a shorthand. It says it keeps, instead of the procurement being 150 pages, it's only 75 pages or whatever, because we simply list the clauses. Let's kind of go back for a moment. I want to look at the table of contents. Notice there were 12 pages here of contract clauses. I can assure you that for that procurement, there were more than 12 pages of clauses if you spelled them all out. But they didn't. They had a list of clauses. They may have spelled out some of them. That's why it's not just 2 or 3 pages. And you have to remember that when a clause is put into your contract by reference, it's just as binding as if it were spelled out. So the eyes sometimes gloss over and you kind of scan through it. You have to look at every single clause. If you're familiar with it, then you may be able to say, okay, I know what that clause means. This is a changes clause. I've dealt with it over and over again. I know what it says. But you want to be careful. Sometimes you are familiar with the clause, in a particular context, but maybe not other aspects of it. So you may still want to look at it. A good contract administration practice that we used to do was when you had a contract with a lot of clauses incorporated by reference, the contract administrator would print out those clauses and keep it in the contract file, so you would know what they were. Now, why? Well, because clauses change. If you look at today's version of the FAR, you'll see the clauses listed with dates. And of course, with the RFO, you'll have a number of clauses that have been revised and updated with new dates, more recent dates. The clause that's in your contract is the one that applies. If you're issued a contract in, let's say, 2022, and you have certain FAR clauses at that time, those clauses remain even when the clause is updated, unless, of course, the contract is modified to change your clause. And it may be. Sometimes contracting officers will say, we have a new version of this clause, I want to put that into your contract. Why would they do that? Well, the new version may be better, they like it better, there's a reason it was changed. Or it may simply be the contracting officer wants to have uniform contract clauses for all their contracts. They administer more than one. And they don't want to have multiple versions of the same clause. So they say, look, we've got a new version. We want everybody to have that same version. So they can issue a mod that will change that. Now, what if the change in the clause puts more burden on the contractor? Well, the good news is that you would be able to treat that as a contract change. Yes, it's a change within the scope. The government has the contracting officer has the right to make that change unilaterally, but if it's going to increase the cost in performing the contract, or it's going to delay the performance and increase the time needed, then the contractor will be entitled to an equitable adjustment for that change. Now, one of the things to note, kind of at the bottom, and we'll come back to this again later, is that sometimes when those contract clauses are listed, there are inconsistencies. Sometimes there's a tendency to include, for example, multiple versions of the same clause. What do I mean by that? Well, there might be a version of a clause suitable for fixed price contracts, and there might be one that's suitable for cost reimbursement contracts. And an inexperienced contracting officer might say, hey, more is better. Let's just put both of them in. And of course, there can be an inconsistency. There can be other kinds as well. So if you're the contractor looking at the clauses in your contract, be sensitive to clauses that may give different direction, or they might be inconsistent with something later elsewhere in the contract. And as we'll see, if there are, you need to identify those so that you clarify that before the contract is performed. Okay, moving on, we have section J, list of attachments, basically things like the drawings and the wage determinations if it's a Service Contract Act contract, contract data requirements list. Often a contract will say there's certain data that has to be turned over to the government, and that will be found in the CEDRL. One of the traps that the government sometimes falls into is they might ask for some, let's say, software and want a license to use the software, depending on who paid to develop the software. It may be an unlimited rights license, or it might be restricted or limited. In any case, the government gets a license. That doesn't automatically mean they get the software to actually use it. That has to be in a separate requirement in the contract, identified in the CEDRL. Often the J will also indicate whether the proposal will be an additional attachment to the contract. Logically, it should be. Contractor says this is what we propose to do. When the government accepts that proposal, that becomes a binding contract, so logically it should be in, but it isn't always technically. Okay, then you have the last part, part 4, which has some pretty important areas, especially if you're in legal or in contract administration. These are the areas you're going to look to. K will be the representations and certifications. L, instructions, and then M, the evaluation factors. So let's look at those. K, what we call the reps and certs. That's where the contractor indicates, is it a small business? Is it going to be performing the contract in a hub zone? Is it a women-owned business or a disabled veteran-owned business? A number of things about the business. It used to be that those were filed in paper. Now, most of the time, that's done on an annual basis in the systems for award management into SAM. L, instructions, notices to offerors, and that tells you how you should be preparing your proposal or your bid, how it'll be organized, where you submit it, when you submit it, any other constraints on that. So for example, if it's an invitation to bid, it will typically say submit the bid no later than noon on February 22nd in room 2032 of our building, whatever. If it's an electronic submission, it will indicate again how you would do that and the deadline for that. And you want to be careful if it's electronic, make sure that you've sent it in. If you send it at the last minute at 11:59 and it's due at noon, you're basically on, playing with fire, because sometimes the system won't let it go in within a minute, and it's received at 12:03 and it's too late. You want to allow enough time. So here's an example of a section L. This would be more in a Part 15 procurement. And of course, that's much more sophisticated in what's asked for than just a single bid. So here you want an original, 2 copies of 2 different documents, the offer and award document and the technical proposal. It shows you how you should mark them original and duplicate. Here's another example, which is explaining that the government may award the contract without discussions. So this is again for Part 15. You're submitting your proposal and you anticipate, or you may anticipate, that there'll be another round. You're going to get questions back. You're going to get discussion items. There might be a down select to critical, the critical proposals, the most likely to succeed proposals. And the government here is telling you, well, wait a minute, we may not do that. We may just award on the basis of initial proposals. So you better be careful when you submit your initial proposal. You want to put your best foot forward, give your best price, because otherwise you may lose on the basis of the initial selection. And that may sound pretty obvious, but it's not so straightforward if you're not sure you can give your best price. Yes, for example, let's suppose you have a team and you have a proposal where your pricing has to reflect your subcontract prices to you. You're the prime, and you could be conservative and say, all right, if I take all my subcontract proposed prices and then put in my costs and reasonable fee on top of that, here's my price. But you're afraid it may not be competitive, and you're going to have to go back to your subs and ask them to lower your price, lower their price. And the question is, where are you going to have a chance to do that? If award is made on initial proposals, you don't. On the other hand, if there going to be another round, then you would have a chance to do it, and you would be more conservative in your bidding. So this becomes a business kind of tricky business issue. Okay, and then we get to section M, the evaluation factors, and this is important, particularly if you're counsel, and especially if you're looking to see whether the award was made appropriately and maybe considering a protest. This is where the agency is indicating how it's going to make the award. Now, if it's a Part 14 invitation for bid, you know how they're going to make it. It's got to be the low bid, as long as it's responsive and responsible, as long as the bid is responsive to the invitation for bid, all the details of it, and it's a responsible bidder. So there's no real complexity here. It'll be, a one-page section M. But if it's a Part 15, then there may be lots of complexity. For example, is this going to be a low price technically acceptable, or is it going to be a best value price technical trade-off? Or we have a new method of selection in the RFO, in the Revolutionary Far Overhaul, which would be the best technical proposal as long as the price is reasonable, which is kind of the mirror image of LPTA. And then after indicating especially best value, then how is the best value going to be calculated? What are the evaluation factors and sub-factors? What's their relative importance? What's going to matter? And you can, and the RFP can do this in a number of different ways. It can give percentages. It can say technical is 70% and price is 30%, and within technical we have management capabilities 15%, and subcontract management is 10%, and past performance is 20%, whatever it is. It can be algebraic. A is twice as big as B. It can simply be in order of importance. The most important is factor A, the next is factor B. It can even be a narrative statement. A lot of different ways to do that. Now, what has to be in those evaluation factors? Well, the FAR actually gives some guidance and some restrictions here. Every evaluation has to include quality in some fashion. And it doesn't necessarily indicate what that fashion is, but it gives the FAR gives some guidance about what it might be. So it might be the technical approach, it might be the management approach, it might be the personnel qualifications. It could also be past performance. In fact, every procurement has to include past performance in some way. It might be the data rights, it might be the subcontracting plan. These are all different factors that go into Section M. Then you have the cost price factor, which has to be in every procurement as well. Price if it's a fixed price proposal, cost if it, or predicted cost if it's cost reimbursement, and has to explain how that will be calculated if it's not clear cut, how you're going to evaluate the price, and of course what the relative importance of price or cost is. Here's an example from Section M. The basis for the award: the government will base the award on the best overall value, best value proposal, considering price and other factors. Price is less important than the other factors combined. Doesn't give you a number. And then it gives the evaluation factors, the other factors, technical, and the sub-factors equal in weight. Post office operations, management plan. This was a postal service procurement. Another factor, past performance, and then price. And then note at the bottom, evaluated price is the sum of the CLIN prices for the base year and all the option years, even though the government is not obligated to exercise that option. And you better put in an option price for every year, otherwise it's not going to be responsive. So that's an example of the guidance. Here's another example, technically acceptable low price. Intends to award an IDIQ contract fixed price to the lowest price technically acceptable for. And then it indicates what technical acceptability will be determined by. And you can see there are 3 different factors that are in there, and that's amplified further in the rest of the RFP. So that's kind of a summary of what will be in the solicitation, and in most respects what will be in the contract. Section M, of course, isn't in the contract. You've already awarded it. You don't need an evaluation factor. But most of the other sections will be. All of the statement of work in Part C, and the pricing in Part B, and the delivery, and all that kind of thing. You will find that pretty much word for word the same in the actual contract. Now let's look at what we do with the contract, how we interpret it, and some of the traps that we don't want to fall into. So first, let's make sure we know what we're talking about when we talk about the contract. Um, and remember that the contract, in the interpretation of the contract, you want to make sure meeting the minds. I mean, I already said you have a binding contract because you have a proposal, which is the offer, the award, which is the acceptance, a meeting of the minds. But is there a meeting of the minds? Do both sides understand the same thing in the contract terms? Um, many times you will have disputes and problems that arise because the contractor thinks the contract says one thing, the contracting officer thinks it says something different. And so we have a lot of guidance in the what I'll call the common law, the contract interpretation of basically when there's a dispute and there's a decision on the dispute, typically by either the Board of Contract Appeals or by the Court of Federal Claims, and that interprets the contract provisions, sometimes interprets even the FAR clauses. So you have case law. The case law will apply to a particular case, but the body of those cases becomes what we call the common law. This is a system in American jurisprudence, borrowed really from the English, where yes, you have a lot of statutes, you have a lot of regulations, but there are always questions that those statutes and regulations don't answer, just as there are questions the contract may not answer. And there are gaps between them, and it's the judicial decisions that wind up filling those gaps. That's what we call the common law. One of the interesting questions, so just kind of flag this for future thought, with the RFO, one of the things the RFO does is it moves a lot of the FAR guidance, things that are not statutorily required, into what are called buying guides or companion pieces. And query, to what extent will those be considered binding, and to what extent will the common law that's developed around the FAR also apply when we have them as buying guides, but not as FAR requirements. So let's look at the first do's and don'ts. Read the solicitation carefully. Kind of obvious, right? I mean, we all know to do that. Well, yeah, you gotta be careful. Often we take shortcuts. We think we know what it says when we don't. We look at that FAR clause and we think we know what it says because we dealt with it some other time, but we haven't really read all of it. Or we forget about those FAR clauses. We pay attention to the things that are spelled out. We ignore the list of clauses, but they're incorporated by reference. They're binding just as much as if they were spelled out. We submit a proposal that doesn't conform to the requirements of the solicitation. It's going to get thrown out. These are the traps to worry about. Here's an example of a trap. This was a situation where the solicitation said that there's a page limitation, 150 pages. And the contractor, or the offeror, Texas, submitted a proposal that was more than 150 pages. Guess what? Any page after 150 wasn't read. Guess what? There were things in the parts of the proposal that were necessary to the proposal. And as a result, if we don't consider parts, pages 151 through 200, let's say, then the proposal is no longer responsive. It doesn't cover everything it needs to cover. Texas protested. They lost. Second, and I mentioned this earlier, you want to address the ambiguities that are in the solicitation. And we usually think of two different types of, or let me say it this way, ambiguities fall into two different types, two different buckets. They are either patent or latent. A patent ambiguity is one that you can identify just from the terms of looking at the terms of the contract. If you're an experienced person, you should be able to spot that. It's on the face, it's apparent. It's something that's clearly missing. It's something that's clearly inconsistent. You look at the drawings and you look at the specifications, and the drawings say one thing and the specifications say something different. There's clearly an ambiguity. Which one governs? Now, that may be resolved by the order of precedence clauses. It may be resolved some other way. But if it's not clear, then if you're the contractor, you have a duty to identify it and tell the government, wait a minute, this is ambiguous. If you don't, then you're basically subject to whichever one the government says applies. So you look at the ambiguity and you say, well, we're going to read it this way because this is the way we like it. This is the way maybe we could do it cost less. And the government says, no, you were wrong. The ambiguity should have been clarified, but you didn't identify it, so we're reading it the other way. You need to identify those ideally before the proposals are due. If you don't, and let's say you protest afterwards, we interpret it differently. Well, you should have identified that patent ambiguity before you put the proposals in. Now, that sounds pretty straightforward, but there's a little bit of a glitch, a little bit of a potential trap. How do you identify the ambiguity? A typical way of doing it is by submitting a question during the procurement. In fact, typically, if it's at all a complicated procurement, there will be a provision in the initial RFP that says any question should be submitted no later than XYZ date to the contracting officer, and then typically those questions will be addressed in an RFP modification or RFP mod. And that mod will list all of the questions and all of the government's responses. It may not always give you the response you want, may not always give you a clear response, but at least it will respond to each question. But that means it will respond to every offeror's question, and every offeror will get to see the answers. So if you are an offeror and you say, gee, I wonder whether, we have this really clever way of dealing with this requirement. We have a whiz-bang novel approach that we want to put in our solution, but we're not sure the government's going to accept that. Well, we could submit a question that says, will you accept this whiz-bang approach to the solicitation? And we'll get an answer, and we can then decide what to do. But if we do that, we are flagging to all of our competitors that this is a possible way of addressing this issue. Do we want to flag it? Or do we want to take a risk and hope we're right, hope we understand what's allowed better than not, so we don't give away our competitive advantage? Which is the right answer? Well, it's a business decision. There's no right or wrong here. You need to do it with your eyes open. If we flag it, everybody gets to see it, but we get more certainty in knowing which way to go. Maybe it's something which we're the only company that has the capability of doing this, in which case the risk goes down. Okay, now I said there were two kinds of ambiguities. There's also the other kind, the latent ambiguity, and that means something that you really wouldn't spot it just by looking at the solicitation. Now, that means you don't have a duty to flag that issue if it's not one that you can spot. But once you do spot it, once maybe during performance of the contract, you realize, well, wait a minute, we looked at the drawings and we see that this drawing is of a piece that has a tolerance of plus or minus 1/10 of an inch, and this drawing has a piece that's a plus or minus of 1/10 of an inch. And there's no obvious ambiguity until we realize that when we put those two pieces together, and if each piece is at the outside of their tolerance, they won't fit. Well, that's not a patent ambiguity, but now we realize that. Well, we have a duty to raise that as quickly as we can. And if you say, as part of the raising, well, we interpreted it this way, it has to be a reasonable interpretation. There's also a Latin phrase called contra proferentum, and let's talk about what that means. That means that the language of a contract will be interpreted against the party that drafted it. And this is true not just government contracts, but just in general. If I draft a provision and it goes into the contract, and that provision is ambiguous, and the other side looks at that and says, well, we interpret it differently, and their interpretation is reasonable, then it's my fault for the fact that it's ambiguous. I was the one who drafted it. And so I'm bound by the other party's interpretation. Contra meaning against. Proferentum means the one who profers the contract, the one who offers the contract language. Now, that doesn't apply if the language is back and forth and basically drafted by both parties. It applies only when one party is responsible for the drafting. And as a result, there are times when the government will actually try to undo that risk shifting, risk bearing approach, and say, well, wait a minute, this is a part agreement. Any ambiguity will not be strictly construed against the drafter, but rather will interpret it the most reasonable way, etc. Basically saying, well, wait a minute, yeah, this is a government contract. We provided the terms, but you have every opportunity to look at it and review it, and you better do so because you're going to be bound by it too. And of course, in a government contract, prime contract level, it's the government that typically is writing the clauses, not the contractor. A little different, perhaps, in the subcontract. Okay, here's an example of a latent ambiguity. Solicitation said the technical approach shall not exceed 15 is basically a page limitation. And then it says resumes, schedules, table of contents, cover page, cut sheets, drawings, etc. are not counted in the page count. So what happens? Well, the org chart is included in the proposal, but it goes past the 15-page limit. The offer says, well, that was not included in this 15-page limit, even though, well, org chart isn't spelled out. It's not a resume, it's not a schedule, it's not a table of contents, not a cover page, not a cut sheet, not a drawing. So the protester, whose bid was thrown out, says it's not a drawing, but it's in the etc. Etc. means other similar things. JO agreed with them. Said, that's right. That's a reasonable interpretation. It's a latent ambiguity. There's more than one reasonable interpretation. So latent ambiguity, protester wins. Okay. Third guidance. The contract, you have to read it as a whole. Now, wait a minute, Fred. Didn't you just say earlier that you look at your part of the uniform contract format means you look at your part? Sure you do. That's what's most important to you. But in interpreting the contract, sometimes there will be provisions elsewhere in the contract that help interpret it. And the contract is going to be read as a whole. Okay. And that, of course, includes the full text of the incorporated FAR clauses. So you got to be careful if you just look at the specs and don't look at the drawings, or vice versa. And that bottom bullet is important too in a kind of a broader way. Not only do you want to get things right, but when you're making arguments, when you're interpreting contracts, when you're claiming that a contract says this or that, when you're really taking any kind of a contractual or legal position, you want it to be the right one. You certainly want it to be credible. And if you say something that's not, if, for example, you say, well, wait a minute, I interpreted it this way, and the response is, well, you should have looked at this other part of the contract that clarifies it. Yeah, it's true that the drawings are different from the specs, but the order of precedence clause makes it clear that the specs govern. Then not only do you lose the argument, but you lose some credibility. It kind of impairs your ability when you're making other arguments, which might be much more valid, but you've kind of undercut your credibility because you didn't, you made an argument earlier that was clearly wrong. you want to be careful about making arguments that are clearly wrong. It's okay to make a defensible argument where you have a basis, but be careful about undermining your own credibility. And of course, this is when I talk about FAR clauses being incorporated by reference, this is the actual language in 52.252.2. Incorporates with the same force and effect as if they were given full text. Now, going back again to what we said earlier, the date on the clause matters because the version that will govern your contract is the version that was in effect when the contract was awarded, unless it's been modified. But it's not automatically modified merely because the FAR has been updated. So all of the clauses in your contract, let's just use the RFO as an example. The Revolutionary FAR overhaul has modified many, many clauses, many standard FAR clauses. And in the case of the agencies that have adopted those through the class deviation process, and in the case of it will go to rulemaking, and so eventually, some or all of those changes will be incorporated by rule. The FAR clauses will be different, but they won't be different in your contract unless the contract is specifically modified to do that. Now, there's another catch, which is something called the Christian doctrine. It's not a religious doctrine. It's a doctrine that comes about because of a case called where the contractor's name was, I think, J.L. Christian and Company. And basically it says that even if the clause isn't included in your contract, if it's a mandatory clause that should have been included in your contract, and if it's important, if it's a significant strand of public policy, then we're going to incorporate it in the contract as if it was in there. In the case of the Christian case, GL Christian, I think I got the initials wrong, it was a termination for convenience clause that wasn't included. And as a result, when the contract was terminated, the contractor says, hey, you're not allowed to terminate for convenience. And so we have to treat it as a breach of contract. In a breach of contract case, I get to be made whole, so I get my lost profits. And the Court of Federal Claims, what was it called, the Court of Claims back in the day, said, sorry, we're reading that clause into the contract as if it was specifically put in. Why? Well, the contracting officer didn't have the authority to waive the clause. And no, it's not being unfair to you. You could have looked at the FAR and you would have known there was a mandatory clause. So you were on constructive notice, even though you may not have actually looked, you were on notice of it. And it has been applied to many other standard mandatory FAR clauses. Okay. 4, understand the statement of work. Why is this an issue? Of course you should understand the statement of work. Well, sometimes in the evolution of a procurement, it starts with the program needing something, putting in a request, we need this equipment, or we need these services. And it goes through the procurement process. The contracting officer issues a procurement based on that need and ultimately issues a contract based on the need, but maybe the final contract is a little different from what the program actually wanted. If it's a best value procurement, maybe the best value will not be the best value as the program wanted. They wanted a Cadillac car, and when it went through the procurement process and the best value was picked, it turned out to be a smart car, a small car, or maybe it was a motorcycle because that's really all that was needed, and that was the best value. So you have a different expectation between what the program wanted and thought they were going to get versus what the contract requires. And the contractor can be caught in the middle. You want to satisfy your customer, but you don't want to be doing work that you're not going to get paid for because it's not required in the contract. Sometimes that leads to a constructive change. The government interprets the contract a certain way, and you don't interpret it that way, and you think that interpretation is adding to your costs or the time needed to perform the contract, or the government delays, or the specifications are defective. They ask for something and it can't be done. Or the government knows you're going in the wrong direction and has superior knowledge of that and doesn't tell you. Um, all of those are potential constructive changes, and you want to be if you're the contractor, you want to be very aware of that. Any request for work that's not required in the contract, especially in a fixed price situation where you won't get paid for it unless the contract is modified. So how do you deal with it? Well, A, you have to recognize it early, and B, then you say, all right, I'd love to do this extra work. I'd love to give you weekly reports instead of monthly reports because you would like that. Or I'd love to change it so we um, do rivets every 2 inches on the jet plane instead of every 4 inches. But that's not required in the contract. So let's go to the contracting officer and mod the contract. Now, shouldn't the program be doing that? Well, of course they should. But sometimes the program and the contract shop are not not working together, not communicating well. They may be in different buildings. They may be in different cities. They may not know each other. And so it's sometimes the contractor who has to kind of bridge the gap in a tactful way. But if you don't, you can be caught doing work that you're basically going to be treated as a volunteer and not get paid for. Um, if you do it to exceed your customers' expectations, that may be the right business decision, but do it with your eyes open. Know that when you do it, you run the risk of not getting paid for it. Another area where this can come up is contract hasn't actually been signed, but you expect the award, so you start performing it. Or there's a government intent to award, but it's not a binding contract yet until there's an award. Maybe it's an unfunded contract. We want you to do this, but we don't have funds yet, so there's no legal liability until we issue the funds. So you're the contractor. What do? Well, you perform the contract, you start working on it, well, maybe, but you're at risk, and you may never get paid for it if the funds are never appropriated. Well, what if it's a contract where once the funds are appropriated, you're going to be on a tight time schedule. So you really have to be prepared and start working even before you get the award. Again, that's at risk. And there's actually a FAR principle that says in that situation, yes, you are allowed to treat that as an allowable cost if you win the contract, if it's awarded. But you're at risk if it's not. Should you do it? Well, how confident are you? And are you willing to make the business decision to go at risk? You're already at risk just by incurring bid and proposal costs. After all, if you don't win the contract, those B&P costs don't get reimbursed. So it's not as if this is, some cataclysmic, risk, but it is a risk. You're not going to get paid. Notice, what if there's a contract change, and especially a constructive change, something that's going to cost you more money? Well, there's a clause, the notification clause in the contract, and typically when that happens, contract officer says, "I'd like you to do this," and you say, "Well, it's going to be changing the contract." Contract officer says, "Okay, give me a cost proposal." So you put them on notice that initially that it's a change that will cost more money, and then second, the actual cost of the change. Here's where the timing matters. Sometimes the government does something, asks you to do something, or maybe delays something that increases your costs, and you don't recognize it right away. And so you're asking after the fact. You're saying, "Oh, guess what? This happened, and it cost me more money, so here's my change proposal." That's not as good as doing it before. If you have something that's going to cost more money, if you identify that before the work starts, then you have the ability to modify what's being asked for. Contracting officer has the ability to say, "Oh, I didn't realize it would change, it would cost all this much more money. So instead of doing this, let's do that." If you wait until after the changed work is performed, somebody's got to pay for it one way or the other. You no longer have that option of changing the work scope. A good example of that is something I'm going through today. I have my car in for some servicing, and there may be, I haven't gotten my cost estimate yet of what it's going to cost, but there may be options that say, all right, if it costs, $100, yes, it's worth doing. If you tell me it's going to cost $2,000, let's look for an alternative. And there may be alternatives, but it only works if they tell me beforehand. If they say, well, we just fixed it, here's your bill for $2,000, it's too late. And I might, be stuck with it if I didn't say, ask me first, which of course I did. Okay, first rule of government contracting. Not enough to do what's required. You have to be able to prove you did what's required. You have to document. Don't rely on your memory. Your memory fades. The people who remember are no longer in place. They've changed jobs. Maybe they left the company or left the government. And if you document everything along the way, it makes it a lot easier to resolve and often avoid any dispute. If it's a task order, don't wait till the contract's complete. Do it along the way. Contract closeout is an example. I sometimes ask, when does closeout start? And the correct answer is when you win the contract, because that's when you know what will ultimately be required at closeout. And so you can start maintaining the files that allow you to have the documents in place at the time of closeout. It's when you can assign somebody to be responsible for those files. If there's a contract modification, document it. If you do something that has to be done and you want to modify the contract accordingly, you want to do that and you want to document everything along the way. Ideally, get the contracting officer's modification in advance or ratification afterwards, but otherwise make sure you've documented it so you know what was done, and make sure you bill appropriately and you don't say, I delivered, this is a bill for widget 103, which is green computers, but actually I delivered blue computers because they're the newest model and they're better. Well, that's all well and good. And the contracting officer knew about that and he was happy with it. Well, you still, when you bill, when you invoice, you want to say it's widget 103, except I delivered blue computers instead of green computers. And you avoid any possible argument by the auditor that that was fraudulent. Understand the rules. They're not always intuitive. You need to understand the FAR. It's a roadmap for the contracting officer, which tells the contractor where the contracting officer is going, what they can do, what they can't do, what they need in order to do it. A former colleague of mine, Michelle Williams, used to say it's like playing poker. Government holds the high cards, but they're marked, and the markings are the FAR. Okay, an example from FAR definitions. Contracting officers, the FAR says the contracting officer shall do something. Well, it's a mandatory. I mean, in our normal vocabulary, we often say, I shall go to the store today. And what we really mean is I plan to go to the store. But if I decide to change my mind, nobody's going to say I lied. I really did intend to, but I changed my mind. Well, if the FAR says the contracting officer shall do something, can they change their mind? Does it mean they're likely to do it or they might do it? No, it actually means they must do it. Shall means must. Shall means the imperative is the way the FAR defines it. By the way, the revolutionary FAR overhaul deletes a lot of shalls, but in many cases it replaces them with musts. So maybe it reduces the ambiguity, but it still means, yes, they have to do it. Understand the contract requirements, of course. Things like notice requirements, limitation of funds. If you're in a cost reimbursement contract, it will have a cost ceiling. The government can't give you a blank check. That would violate the rule. What is it? I forget the name, but the statute that basically says the government can't commit to money it doesn't have. So you have to give notice when you're approaching the cost ceiling. If you don't give notice, you're basically going to be trapped if you go over that cost ceiling. Understand your rights. Understand what you can and can't do in the government. And understand potential avenues of relief. I sometimes tell contractors, if you ask me in advance what you should do, I will generally say, be very conservative, document everything, don't do something at risk if you don't want to take the risk of not getting paid for it, yada, yada, yada. But if you come to me afterwards and say, this is what I did, and I wasn't conservative, and I did give appropriate notice, and I went at risk, then I'm going to say, all right, well, let's see if there are arguments that say the government is responsible for this. Was it an excusable delay? Was it a constructive change? Did it breach the government's duty of good faith and fair dealing? Now, not every overrun by a contractor will be something that the government's responsible for. But if you're the contractor, you should at least look at those possibilities. Verbal authority. You get verbal authority from the government. Well, often, as Samuel Goldwyn used to say, a verbal contract isn't worth the paper it's not written on. You need to modify the contract in writing. If it's verbal, it may not be, it may not bind the government. And of course, the verbal authority, the written authority has to come from someone who has the authority to give it, which is the contracting officer. Only the contracting officer can modify the contract, can bind the government contractually. And even then, only to the limits of their authority. They may only have a signature authority up to, let's say, $1 million, and you want to negotiate a mod for more than $1 million, that contracting officer can't sign off on it. They need somebody higher authority. And that matters. That matters if you're negotiating the contract. Whose approval do you need, and whose approval do you want to be writing for? And maybe you want to accept modification of $1 million because that's the limit of their authority, rather than raising the issue of where you think you're entitled to maybe $1,050,000. It's a little bit more, but it's going to be a lot more burdensome, and you might not get that authority from the head of the contracting authority. You might not get that approval. You need to take direction from the contracting officer. This is what we talked about earlier. The Corps may tell you to do something, and it's not contractually required. It's voluntary if you do it. And flip side of that is the contractor, unlike the government, the contractor is bound by apparent authority. Government's not, but the contractor is. You have somebody who appears to be having the authority. You have your account manager who is negotiating with the contracting officer and appears to have the authority to do so. You're bound. The company's bound, even if maybe they didn't have signature authority. Maybe under the company's internal rules, that account manager shouldn't have been negotiating that. So if you're the contractor, you want to have some clear chain of command, some clear channeling all contractual communications only through a single person, a contract administrator. Be aware of the order of precedence clause. It may resolve that ambiguity we talked about. It may say the schedule is binding over the drawings, and then that apparent ambiguity goes away, and even the latent ambiguity goes away. Be aware of trade practice. Sometimes the trade practice will govern the way contracts should be interpreted. For example, and sometimes there'll be standard practice in a given contract, and when it changes, that may also lead to differences in how the contract is interpreted. For example, the inspections suddenly get much more rigorous. Yes, they're permitted to be rigorous under the contract, but when the contractor bid that contract, they bid on the basis of the inspections for the past 10 years had been done a certain way. They had a right to interpret it that way. Time-honored practice in one industry may not apply in another. You want to be careful about that. If you're the contracting officer, you want to also be careful about that. Subcontracting. You've got to work together with your sub. Subs have to work together with the prime. That means flow downs from the prime contract need to be looked at carefully. Contractors shouldn't just prime shouldn't automatically include every single potential flow down. The sub should look at what's being flowed down to see whether they apply. A good example of that is the changes clause or the termination for convenience clause. Neither of them are mandatory flowdowns. Both of them are necessary to protect the prime. But both of them, if simply flowed down unchanged, would give the prime authority to make changes unilaterally, to terminate for its own convenience, that go beyond what it actually needs to protect itself from government changes and government terminations. The subcontractor can resist that and say, hey, we'll accept the changes clause, but only to the extent the government makes changes in the prime contract. We'll accept the termination for convenience clause, but only to the extent the government actually terminates the prime contract for convenience or our part of it. Commercial items contracting. There is a preference for commercial items subcontracting even when the prime contract is not a Part 12 commercial items contract. By the way, I say commercial items, it's really commercial products, commercial services. That's been separated in the definition. And sometimes the prime contract administrators get confused about that, and they say to their subcontract administrators, you need to flow down all these prime contract flow downs. Well, not necessarily. If it's the subcontract is only a subcontract that's a commercial item subcontract. Look at the details. Okay, the details can really bite you if you don't. Be aware, if you have a GSA schedule, be aware of the price reduction requirements that you have to disclose your commercial pricing, and then when it changes, when your catalog changes, or you offer some spot discounts, you need to make sure you've disclosed those to the government. Do what makes sense. The FAR currently and the revised FAR, the Revolutionary FAR Overhaul, make it clear that the government the contract officer has discretion. If the FAR doesn't prohibit it, they can do it. It's got to be in the best interest of the United States. But if you're the contractor, be aware of that. Be aware the contract officer has that discretion, and you don't have to prove that this is, you make a request for an action. You don't have to show that it's allowed under the FAR. You just have to make sure it's not disallowed, not prohibited. And then, of course, you want to make the argument for why it's in the government's interest to do that. Otherwise, the contract officer won't bite. Don't let sleeping grizzly bears lie. If there's a problem, it doesn't improve with age. Be proactive. Resolve it early. There are common traps that you sometimes fall into. I don't want to tell my manager. I won't get the bonus. What the contract officer doesn't know won't hurt. No, it'll kill you. Don't tell the lawyers. They'll get me in trouble. No, they will help you solve the problem. This cure notice is just a shot over the bar. Wow, no, take it seriously. And then, of course, maybe the pig will fly. Problem will go away. Won't have to address it. I put that in for the graphic, of course. So the best practice is to work together. It's a virtuous cycle. Okay, both sides benefit. Government and industry benefit when the problems are resolved early. So now we have some questions that you need to answer. These are the polling questions, I guess. So, Josh Lee, I'll let you take over on this.
Thanks, Fred. I'll go ahead and read that out loud. When addressing non-commercial items, must the changes clause be included in the subcontract? I'll give you guys a moment. All right, I'm going to go ahead and close that. It looks like we've got 39% selecting A, 28% selecting B, 16% selecting C, 13% selecting D, and 3% selecting E.
Okay, well, let's kind of parse that. Is it a mandatory flowdown? No, it is not. The government doesn't care whether the prime contractor protects itself by including the changes clause or not. Not a mandatory flowdown, but yes, it is necessary to protect the prime contractor. So B is a correct answer. Is it included under the Christian doctrine? No, it's not, because it's not a mandatory flowdown. Is it negotiable? Yes, it is. The subcontractor can refuse to accept it. Now, it may not get the subcontract if it doesn't accept some form of the changes clause, but it can resist giving the prime contractor the unilateral right to make changes. It can say you can make changes, but only when the government changes your prime contract. So the best answer is B is a good answer, E is a good answer, and D is not incorrect. And how that negotiation will go will probably depend in part on leverage. If the prime needs the subcontractor, it's going to have to accept the contractor's limitation. On the other hand, if the sub needs the prime, it may have to allow that unilateral right to make changes. And that's not necessarily the end of the world, but it does give the prime more leverage. All right, let's do another question. If the FAR clause is updated, the revised clause will be included in your contract. And the question is it automatic? Is it if the contract's modified? Or does it depend on the contractor agreeing? And here we have a strong consensus, though not unanimity, in favor of B, which is the correct answer. It's not automatic. It's not automatically included, but the contract can be modified and then it's included. The contractor does not have the right to refuse the modification. It is a change within the scope of the contract, and so the government contracting officer can make it unilaterally. But the contractor is protected if that change will increase its costs or the time for performance. It will be entitled to consideration, basically an equitable adjustment. And let's go with one more question. I think it's our last one. The rule of contra pro forentum. Is it a rule of contract interpretation that says ambiguities are interpreted against the drafter? Is it a Central American policy preference? I guess that refers to the Contras in Panama or wherever it was, whatever. Is it a maxim to be skeptical in reviewing testimonial proffers? Is it an evidentiary hurdle that must be overcome in bid protests? And again, we have a strong consensus, which is correct, that it's a rule of contract interpretation, which says that ambiguities should be interpreted against the drafter. Contra, it means interpret against. Pro forentum means you've been the one who offered the contract clause. And with that, we went a few minutes over. I apologize. But with that, we are completed. I will stick around if there are other questions.
Thanks, Fred. We did have some questions come in.
Okay, good. Let's
Davis.
Let's look at those. All right, can you tell me what they are? I can't see them on my screen.
Yeah, Britt Davis asks, does this mean that a proposal becomes a contract absent a mutually signed contract? She submitted that at the very beginning of.
Does a proposal become a contract? What were the rest of the words?
Absent a mutually signed contract.
Well, it becomes a contract when there is an award, and the award then is the government says we award this contract to XYZ company on the basis of its proposal, and it's the contract that becomes the award, becomes the contract. The award will often incorporate the proposal, but it doesn't have to. It could be simply a separate document that doesn't incorporate the proposal. And in fact, when the award is made, if the award is, here is the contract award, the contractor should make sure they review that award document and make sure that it's consistent with the terms of their proposal. You don't want it to be an award for something that's different from what you proposed. We had a contract, I remember years ago, where the contract, we were told that we were going to win the contract. It would be awarded and signed on a Friday of that week. And we were invited to send somebody in on, I think, Wednesday to review the award document to make sure that it conformed with our proposal. which led to some interesting internal things involving who would know about that award. And the people who were reviewing it, of course, and the notification was sent to people. So some of us knew about the upcoming award, but we were not supposed to make that public. And there was an interesting division of labor in terms of notifying the powers that be in the company, because different people like to know about an award. It was a major award. It was $1 million contract, $1 billion contract, sorry. And people like to be the first to know. So it was a little bit of an interesting experience. Other questions?
Thanks, Fred. Our next question from Gladys. What when contractors do not without dates and state it is the clause effective
All right. I think I
the
missed
date of the
some of your words. Could you repeat that?
Gladys wrote, "What to do when prime contractors do not provide clause with dates, but rather clauses without dates and state it is the clause effective the date of the subcontract, and do not provide copies of Section 1, only a list of clauses without dates."
If they provide it'd be easier if I can read this. Is there a way for me to see the question? Is it
Let
in
me see if you're able to see them now. You'll have to unmute your mic.
in my feed? Oh, here we go. Okay, good. Okay, so let's. All right, I'm going to look what's in my feed here. If we have a contract during which, and this will be in a different order, so I apologize, Gladys. We'll get to yours. If we have a contract during which negotiation had a term for convenience clause, but it was redlined out and agreed by the parties. Ooh, interesting question. Would the Christian doctrine then apply if it was specifically redlined out? I guess the issue would be if it's a mandatory clause, then the contracting officer did not have the authority to redline it out. So I think if I were the contractor in that case, I would be, probably submitting some kind of a question to maybe the head of the contract authority, to find out whether or not this was an exception. This could be a deviation. You can have I already mentioned earlier class deviations, but you can have an individual contract deviation. So I guess that can be done, but it would have to be done under the contract deviation process. And I would, if I were the contractor relying on that, I would want to make sure that it was done that way. Now, of course, from the contractor's standpoint, I suppose you're not harmed by simply assuming that it will work and hoping that it will work, because if there's no termination for convenience clause, that's limiting the contractor. It's not limiting the government. It's not hurting the contractor. But if you're going to rely on that, for example, if let's say you are going to, let's say you're putting in your financial projections and they include all of the profits that you're going to win during this contract, and you want to be able to book that because there's no termination for convenience clause that would allow it to be terminated earlier, and you're relying on that for booking that revenue, I'd want to be careful about whether you could really rely on that. I'd want to make sure it was done appropriately through the deviation process. Okay, let's look at the next one. See that one. Now I have to go back. Question thread. It's called a limitation of funds clause. Well, I was actually looking for something else, which was the Anti-Deficiency Act is really what the statute that I couldn't remember the name of, and that's why we have a limitation of funds or a limitation of costs clause. They both really say the same thing, but one is for incrementally funded and the other is for fully funded contracts. Okay, and then we have, if you're a newbie GovCon, how would you know what mandatory FAR clauses are included or not included? Would the company contracts person know, assuming there's a specialist? Well, the answer is the FAR tells you. I didn't mention this earlier, I should have, But in Part 52, where the clauses are listed, every one of those clauses will say, include this clause pursuant to whatever section of the FAR governs it. So if it's, for example, 52.215 whatever, it will be governed by Part 15, and you would go to that language in Part 15, which would say, include this clause if it's a fixed price contract, or include this clause if it's a cost reimbursement clause contract, or include this clause if it's for above the simplified acquisition threshold, or if it will be performed within there will be guidance in the FAR about when the clause should be included, and that will tell you whether it's a mandatory clause or not. So that's a good, important question. Let's see. What page are we on? Are we now on Part 4? Okay, we've passed that. What to do when the prime contractors do not provide clauses with dates, but rather clauses without dates, state it's the clause effective the date of the subcontract, and do not provide a copy of Section I, only a list of the clauses without dates. Well, I guess you're talking from the standpoint of the subcontractor, and you get a clause that identifies the clause without dates. Then what you want to do is look at the FAR and look at what clause is applicable as of your date. And then I would respond by saying, we accept this clause as defined by the clause in the FAR with XYZ date. So you are telling the prime, this is the clause we accept. And then if the prime disagrees and says, no, we want this clause to be some other date, they have to say so. And if they say, we want this clause to be whatever the clause evolves to, you say, no, we're governed by this clause. If you want to change the clause, it has to be only in accordance with whatever changes provision there is in my subcontract. We're not going to be just giving you a blanket agreement to the clause, whatever it turns out to be. If the prime contractor doesn't define it appropriately, which is shame on the prime contractor, then in your response, you should define what you are agreeing to. And that's true generally. If the subcontract as proposed by the prime is not specific or is something that you don't agree with, let's say it provides a provision that you don't think you should be bound by, you should respond and say, no, we don't agree to that provision, we only agree to X. For example, let's say it's a cybersecurity clause. And the cybersecurity clause says, if you are dealing with, let's say, classified information or controlled but unclassified information, and therefore these provisions govern, and you're not going to be dealing with that kind of information, then you want to say so. And you say, no, we don't accept that clause because we're not dealing with that information. And it should be negotiated. Then, it's going to be between the prime and the sub to negotiate what the clause ultimately should say. But you certainly should respond appropriately as the sub to protect your interests. Does this mean a proposal becomes a, all right, that's the one we dealt with. So I think I just answered the clause that Gladys did. So yes, I did get to your clause, Gladys, and even though it wasn't right away. So I hope that's good. Those answers are helpful. And if you have follow-up questions or other questions, I'll stick around as long as anybody wants to.
Thanks so much, Fred. As always, we'd love to know how we did today. If you are seeking a certificate, make sure you log into your PCI account. If you have any issues with that, feel free to send one of our team members an email to assist. And with that, I wish you all a wonderful afternoon. If you have any questions for us, feel free to send them through. We are more than happy to follow up. Make sure to check out the PCI website for our upcoming sessions. Thanks, Fred.
Okay, thank you.
Hey, Fred, I'm not sure if you saw that last question that came in.
Is a technical proposal required to submit with a request for a quote? You get a quote on something. Government is issuing a request for quotation. They're saying basically, please quote on responding to this request, and the request is going to be, usually it's a product, but if it's a service, it could be a service that you describe in your technical proposal. You're basically saying this is our quotation. But remember that a request for quote is going to be for either a commercial items contract under Part 12, which if it's a commercial item, of course, you don't need a technical proposal. It's a commercial product or service. And if it's or it could be Part 13, it could be under the simplified acquisition threshold. So it could still be a proposal, but it's going to be, obviously it's subject to that cost limitation. It's not going to be quite as detailed as if it were, a multi-million-dollar proposal. But one way or the other, you have to be describing what it is you're quoting.
She followed up with, "It is for services."
Okay, well, you have to describe the services, certainly, but the request for quotation would normally be saying, we want a quotation for, um, systems engineering services of the such and such level. So that's the services you're providing, and you're basically providing what it is that's asked for in the request for quote. If it's not as specific as you'd like, yes, you could put a technical proposal in with it.
Thanks, Fred.
Okay.
I think that wraps us up. Have a great afternoon, and I hope to see you all again.
Okay. Yes, sir.